Let's talk about the First Amendment rights of students when they speak off campus. So as we know, public schools are essentially government schools. When they discipline students, it's the government disciplining those students. So the First Amendment applies to public schools, not so much to private schools. But public schools essentially have the rule that if they are to discipline a student for their speech, they have to be doing it because that speech substantially interferes with appropriate discipline. And that's from the Supreme Court case of Tinker versus Des Moines. It's from the 60s. So the Tinker test was established a long time ago, but we still get these cases every now and then. Let's talk about a recent off-campus speech example of Mahanoy School District versus BL. So BL are the initials of the plaintiff in that case. She was a minor, so we just get her initials. She was a freshman in high school. She wanted to get on the cheer team, the varsity cheer team, and she wanted a certain position in softball. She tried out for both. She did not make the varsity cheer team, but she made the JV team, and she did not get her position for softball. So she was very, very mad about that. She took to Snapchat. She posted a snap on her Snap story, which, if you don't know, those are up for 24 hours. People get to view them if they're your friends. And that snap showed a picture of her with her middle finger up with the text, F school, F cheer, F everything, basically. So, you know, this gets around. The students who are friends with her on Snapchat see that. They are upset by it. They show it to the coach of the cheer team. And so the school administration basically knows about this speech. She sent this snap onto her Snap story when she was off campus, off the premises, at a store, I believe. So it was not on campus. So she ends up getting disciplined. She gets suspended for the junior varsity team, which she of course made. She was on that for the next year. She gets suspended for the whole next year. So her and her parents sue the school district. They win in the district court. They go up to the Third Circuit Court of Appeals, and the Third Circuit again sides with them. So the U.S. Supreme Court ends up hearing this case based off of a random snap on Snapchat from a high school freshman. So the majority opinion is written by Justice Stephen Breyer, and the Supreme Court comes down 8-1 in favor of the student and against the school district, saying they violated her First Amendment rights. So Justice Breyer says that this was off-campus speech. It was only visible for 24 hours, and it was only to the group of friends, which, of course, if you're on Snapchat, you get to select your friends. You can refuse someone's request. You can send requests. You have full discretion over that type of thing. So, you know, not a good look for the school. So BL wins. Justice Breyer said that, yeah, this off-campus speech, it's going to get more protection generally. It's going to be harder to show that it substantially interfered with appropriate discipline. But he does also point out there are some ways in which schools can regulate off-campus speech, and that would be for speech like bullying and harassment against students and administrators. It would be for failing to comply with the rules of, for example, remote testing. It would be for attempts to breach school security devices. So BL's speech does not fall within any of those categories. It's protected. Then we get a concurrence and a dissent, a concurrence from Justice Alito joined by Justice Gorsuch. And Alito says he agrees with the majority on basically everything, but he just wants to kind of outline a framework for analyzing cases like that in the future. He gives us some categories of off-campus speech, because when you think about it, it's not just a fine line of, oh, off-campus, on-campus. There are different categories of that type of speech. So when people are walking to school, is that off-campus or on-campus? You know, there's some gray. It's not all black and white. So Alito lists some categories. Speech in the public interest. So that's like off-campus speech on politics or religion. That is at the core of First Amendment protection. Schools are not going to be able to punish that. Then we got speech against students. So yeah, students bullying each other, you know, it's a difficult one to handle. It is. So this is all kind of under the doctrine of loco parentis, the idea that the school gets to stand in place of the parents when students are at school. But when students are at home and they're under the supervision of their parents, how much does the school get to do? And shouldn't it be the job of the parents to discipline their students, their children, if they find out that they're bullying another student online? So then we got criticizing the administration. Yeah, so generally the administration wants students to respect them, and it's reasonable in Alito's view for the administration to demand that students show respect. But at the same time, students should be allowed, where it's appropriate, to criticize the administration, because the administration in schools is sure not going to be perfect. Then there's, of course, extensions of school. So basically, after hours, extracurricular activities, speech, for example, on homework that you fill out off campus. So it might not be physically in the building, and it might not be during normal school hours, but the school can still regulate that type of speech. So yeah, there are different levels of permissible regulation depending on the category of speech that one's speech falls in, according to Alito. But at the end of the day, BL's speech did not fall in any of those categories. It's protected. Sorry, school district, you lose. Then we get to Justice Thomas's dissent. He's the only one. He's the most conservative justice on the Supreme Court, basically. And he says, well, the majority didn't realize that we have a historical tradition of allowing schools to regulate whatever type of speech they want, basically. They get wide latitude. And we can abandon that historical approach, but the new rule that the majority created, it's just intuition. And he cites a case from the Vermont Supreme Court from 1859 for the idea that schools can punish off-campus speech. He says he doesn't even know if this snap can be considered off-campus speech. It depends where it was received. If people were reading it while on campus, that would make it more likely to be on-campus speech. But yeah, Justice Thomas strongly disagrees with the majority opinion. And the takeaway we get is that, yeah, off-campus speech is less likely to substantially interfere with the requirements of appropriate discipline. It doesn't mean it's categorically protected, but as we enter the digital age, we have to keep in mind that students should have a lot of freedom to use their social media, their devices, when they're off campus, and only where it falls into certain types of speech like bullying, harassment, really extreme stuff, breaches of school security devices, can the school regulate it. And ultimately, the idea of this holding is just that, yeah, the school didn't justify its punishment. It really didn't. It didn't show that it was necessary. And Alito and Breyer, for the majority, both agree on that. So yeah, those are First Amendment rights when you're off campus. It's a developing doctrine for sure. But yeah, let me know what you think in the comments. What do you think about this case? Do you need some help? It's good to know for your kids if they're going into school, know your rights, know your kids' rights. If you're a law student, I hope this helped you in your First Amendment class. If you're an attorney, I hope this is helpful for you. But yeah, thank you so much for watching. Please leave a like, comment, or subscribe to the channel. As always, I look forward to speaking to you in the next video.